everyone, my name is Ken Vercammen, and I'm an attorney from Madison, New Jersey, and I'm here as a volunteer to talk about what's new in estate planning, wills, probate, taxes, and such, except for federal income tax. So, you know, so believe it or not, New Jersey has decreased a couple taxes, okay? You know, there used to be what's called an inheritance tax, but now, if it's going to spouse, children, grandchildren, stepchildren, there's no inheritance tax. If it's going to any charity, there's no inheritance tax. And if it's going to brothers or sisters, the first $25,000 is tax-free. After that, it's taxed 11%. But everyone else on the planet, it's taxed at 15%. So I only mention that because, and they also have what's called for income tax, a 3-year look back. If you're giving it to non-children members, that they go back this box. Has there been any transfers in the past 3 years? So it prevented someone from saying, okay, the doctor says I'm going to die on Friday. I'm going to transfer my assets to my niece and my nephew to avoid that. Then they get taxed. How do you get around it? Well, if you want to give away some of your stuff now. Let's see. Just like some people want to make what's called specific bequests in their will. Some of the ladies want to give jewelry to a daughter or granddaughter because they know the son, the executive, is going to go to Cash for Gold or Rudy Tangus. What do you give me for this junk? Yeah, good junk. Yeah. You know, something about specific bequests. On the other hand, I was sitting with a client 2 weeks ago, and she's talking about, you know, it was nice, it was expensive jewelry, not the stuff that, you know, she bought at a flea market or she was on a cruise and they were selling at the hut. And he goes, well, let me ask you a question. I said, this expensive jewelry, it was like your mom's ring, your grandmother's ring. Have you worn it in the past 5 years? Yes or no? No. Are you going to wear it in the next 2 years? No. Well, why don't you just give it to your granddaughter now, your niece now? That way, at least they're going to, when they see it next time at you know, Easter, Christmas, whatever, they're going to wear it. Oh, thank you, Grandma, or Aunt Hattie for this. Like, I'm going to show it around. And that way, like, if someone, like, you hate to say, if someone breaks into your house and steals your stuff, but it's fun. Okay, so we also talk about, let's see, a lot of times people will say, Getty, why do I need to have a will done? Doesn't everything go to my spouse or go to my children? I goes, well, yes and no. If there's like if there's children from a prior relationship, then you know, it go, you know, there's a split up. But kind of the important thing is that if there is no, you know, if there is no will, that means that someone, one of the children typically got to, they all got to decide who's going to be the administrator, and then they have to, everyone who's not the administrator has to sign a thing called a renunciation from a notary and have a fee paid to file with the circuit's office. But that's where people get along. A lot of times someone goes, no, I'm not going to sign that, I want to be the administrator. You know, that happens once where someone, I want to. So that means that there has to be a complaint and order show clause in the Superior Court. Everyone on the planet who would have inherited would have to be served a notice to have the judge appoint someone as the administrator. And sometimes the judge will say, okay, you don't like that person and you don't like that person. Well, I'm just going to appoint a third person that you guys don't know, and it's going to cost you a lot more money. How do you like that? So you're not really saving money by not having a will. It's kind of like I was talking to our nice lady downstairs that runs the office. I go, if you had a house in a basement and there's a leak, you know, would you say, you know what, I'm not gonna fix that leak. I'm just gonna let my kids worry about it after I pass away. Not having a will is kind of doing that. Because also, if there is no will, even if everyone agrees upon the administrator has to spend about $1,000 or $2,000 paying this bond fee, and that's for each year that the estate is around. So,
What if you have one kid?
yeah, you have one kid. Here's the weird thing. If there's just one beneficiary, one kid, they still have to pay this fee for a bond. Now, I don't want to say the argument, but I had the argument at the circuit's office of Middlesex. Why does the one son got to take out a bond? He's the only kid. He gets everything. There's no children for the other one who passed away. Why does he get paid a month? Well, that's the procedure. Well, that's stupid. You know, it reminded me of arguing with the telephone pole. You know, you're right. You know, but the telephone pole just isn't reasoning. You know, other counties are cool. He goes, yeah, why waste the money? So, you know, the cost of the will, you're looking at spending $500 or $600. The cost of the bond, you're looking at $1,000 or $2,000. So you kind of save money by having your stuff done right. Now, also, you know, if there's no will, or as the surrogate says, someone cheaped out and did it themselves and it wasn't signed right or done wrong, then there's no will. And then state law determines who gets your stuff, not you. And a lot of times, you know, remember, it's your right to do with your stuff what you want. You could have 3 kids, and you say, you know what? I'm going to give it to St. Mary's, or I'm going to give a bigger chunk to whatever. That's your right. Right? The only thing you can't do is leave a spouse destitute, but there's no requirement of equal. But the important thing is it got to be in writing in the 4 corners of the will. So, for example, let's say on Mother's Day, you know, the mom says, hey, by the way, I want all my jewelry when I pass to go to my granddaughter Shannon. Well, if mom passes, and it's on video, it's all on video, and everyone heard it, you know, not only does the executor not have to follow what that person said, the executor's not allowed to. It's got to be in the 4 corners of the will, and it's not in the 4 corners of the will, then it's no good. Now, everyone says, oh, you know, mom, you know, we're not going to argue everyone is cool. Well, everyone is cool as long as mom's around. A lot of times if mom ain't around,
that's right.
It's the problem isn't your own blood. It's whoever they're married to in their relation that say, when are we getting our money? Or why is that person getting something more than us? You know, we should, you know, so. One of the things the surrogate also says is, you know, it goes, the problem when people do their own stuff is, hey, Dan, can you ask that lady downstairs to bring in more chairs?
There's a chair here.
But, in case so the whole idea is that if,
You missed it.
when the family is grieving, they shouldn't have one more thing to be stressed out and aggravated about, right? I'd say, yeah, I've never had anyone after they did their will say, I wish I didn't do that. Now, sometimes people want to make changes, but let's say, we all have stuff wherever we live that there might be this box of these papers in the corner, and we don't do anything about it. I'll get around to it, I'll get around to it. And all of a sudden, it's a holiday or someone's coming over, and all of a sudden, you start putting the papers away and organize it, and you have that good feeling. You know, when I used to have, when my house, where we used to live, had a garage. And once a year, we clean the garage out and get rid of stuff, or at least hang it up or move it. And you had that good feeling, and that's kind of the same about having to do the will. So, think, you know, a lot of times you think about who do you want to get your stuff, and who do you don't want to get your stuff? Because right, it's your right to do with your stuff what you want. One of our clients said, do I have to treat all my children equally? He goes, yeah, you can do whatever you want with it. You want to give it to the other dogs, you can. She goes, well, one of my sons lives on the West Coast. We don't hear much. You know, we don't hear much from him. I goes, well, let me ask you a question. Did you get a card or call on Christmas, your birthday, or Mother's Day? She goes, no. I goes, why would you give that bum anything? And listen, the day you die, that person's gonna be the first person online saying, where's my money? Where's my money? Let's see, this lady wanted to challenge her will one time. And she hires this attorney and they file a complaint because, believe it or not, the daughter was disinherited, everything went to the two sons. And so the lady's on the witness stand and I go, okay. In 2003, tell me the dates that you visited your mom, who lived in New Jersey, 25 minutes away. None. Okay. How many times you called your mom in 2003? I didn't. Tell me how many times you sent her a letter or card or anything. I did. So, okay. Now, in 2022, blah, blah, blah. Judge finally goes, Mr. Vercammen, I think I got my point. We don't need to go to the next decade. Now, the guy calls me up. I want to challenge the will that was left out. Saying, okay, how many times did he visit your dad last year? I didn't, we had a falling out. Okay. How about the prior year? No. Okay. Did you send your dad a card, email, ever saying, listen, maybe we should have a cup of coffee? We said some things. No. Sir, if it was me, I wouldn't spend my money because what's the judge going to say? Anyway, so, it's horrible for me to say, thank you, in 2020 when the world changed. Because I used to be driving to courts 3 nights a week and in the morning, and then in COVID, everything went to Zoom. But now, and the same thing with doing the wills. I would email the questionnaire, and it was pretty short. They would type it up, and I would email them the will, go, hey, print it out, and then the Staples was allowed to be open to notarize and print stuff. And all of a sudden, you know the cartoons when the light bulb goes off over Bugs Bunny or Elmer Fudd's head, and goes, wait a minute. I should have been doing that for the past 15 years. Now, some of the seniors would say, well, I'm not good with computers, whatever. He goes, oh, do you have a child or grandchild that lives like, not that far away from you in New Jersey? He goes, oh, my granddaughter lives like 2 towns over. He goes, okay. Say, listen, you tell the granddaughter, he goes, listen, I need you to come over for about 30 minutes, type up something for me, and I'm going to give you $5,000 to do it. If the granddaughter or grandson goes, no, I'm pretty busy, I don't have time to help you. Like, okay, no problem, then you won't get anything. Easy enough. I'd say, someone goes, oh, this is one of my Elks Club brethren. Oh, and the form's too complicated. So he goes, you know what, Eddie, okay, I'm making a special form for you. I'm going to dumb it down. What's your name? You're going to type in. You can do it on your iPhone. You type your name, spouse's name, your address, executor 1, which is typically spouse, executor 2, who gets your stuff. If that's too complicated, I probably can't help you. I can't help you out. Now, a lot of the attorneys say, listen, well, you can still fill it out by hand, but they're going to say, we're going to charge you a couple of dollars more if you can do it by hand. Also, I can save money by having it typed. Okay, good. Also, okay, what's something else good? I told the person from the senior center, we have our, the annual newsletter, and it says the estate tax amount. Well, for the person federal, it was raised, so all you people in the room that now have $13,999,000 suffer estate tax. But New Jersey, believe it or not, did away with it. Before that, it used to be $675,000. And for a lot of states, if someone says, hey, I have a house, it was $675, and, so, anyway. So, getting the will done is not that complicated. Name, address, who's executor on, who's executor to the county. You never wanna have joint executors. I'd say, someone might say, I got 2 kids. I trust both of them, I don't wanna pick one over the other. Okay, that's easy enough. You know, I'm at my Elks Club, it seems like I'm at the Elks all the time, but I just say that as, you know, because most of the Elks people are over 60 anyway. Okay, we're writing both of these people's names on a piece of paper, right? Okay, I'm turning it over. Okay, do you want to pick who's the executor? I feel bad. He goes, hey, let's see, Brian, come here. Pick one of these 2 pieces of paper. Okay, good news, client. Allison's going to be executor number 2. And she goes, why was it me? He goes, because because it was kind of like drawing names out of a hat. If there's joint executors, it creates more work in a way, because that means 2 people got to do everything together. 2 people got to go to New Brunswick. 2 people got to sign every check. 2 people got to sign everything, go to a closing. You know, people don't want more work, they want less. And on the other hand, sometimes you got states where they don't get along. I was involved with a contested probate case. The dad made the 2 sons co-executors. These brothers couldn't agree upon what color the sky was. Brother 1, sky's blue. The other one goes, no, it's gray, you're stupid, you've always been stupid. You know, judge goes, fellas, why do you guys go and have a cup of coffee? You're fighting over couches and stuff. Go have a cup of coffee and talk about the fun stuff you did, you know, when you were teenagers that you wouldn't want your parents to know you did. All right, so, now, a will takes care of a will does not list assets. Someone goes, oh, you didn't list my assets. Okay, well, I don't know what you're going to own on the day you pass. Tell you what, email me the day you're going to die, what you own that day, and we'll put it. Otherwise, usually whatever I have on my last day goes to X. And then afterwards, you always want to have a clause. If one of those beneficiaries isn't around, who would get their share? Easy enough. But certain assets don't pass under the will, they pass directly. So, if a house is owned husband and wife, automatically goes to the survivor, okay? Will can't change that. If you have a bank account payable upon death, or 401k, etc., automatically goes to the survivor. The will doesn't change that. If someone assets passed by contract, IRA, 401k, life insurance, annuity. So, it is what I do recommend for people is if they have any assets that have a direct beneficiary, have a printout from the company and just fold it up and put it in the wherever you keep your original will. That way you're making your life easier for the executor. Because also a lot of times the executor can't get into your accounts anyway because you have your secret code. I have some accounts where I don't have a clue what the secret code is. My wife has that. If I went to the bank and signed a check there and wanted to withdraw, the bank would say, we're calling the police. That's not your signature. We've never seen that one before. That's better that way.
Hey, excuse me a second?
Yes.
Does anybody have a blue Honda Civic parked out in the back?
A what?
A blue Honda Civic?
No, sir.
W36DCC? No? Okay, thank you.
Fire.
No, they're kind of parked at least so nobody can sit back there. Thank you.
All right, so, now, so a will, if it already has a beneficiary, the will can't change that. Okay, so, beneficiaries who'll get your stuff, if someone's being left out because they don't deserve, then just one line, I leave nothing to X. No reason, not a dollar, no reason. They know what the reason is. Yeah. On the other hand, you don't have to treat kids or grandchildren equally. Sometimes someone needs it more than the other. So, you know, client goes, listen, I got 3 daughters. I love all of them equally, but daughter number 1 married Dr. Rosenberg, the plastic surgeon. Their second house, Shore House, is worth $2 million. Daughter number 2 does okay. Daughter number 3 married the bum. We never paid child support, etc. She needs it more than the other. You know, if number 1 gets $100,000, she's going to go buy a $100,000 rent. She don't need the money. The other one needs it more. Now sometimes we have clauses in the will that says, listen, I love all my kids equally, but one of them has issues or problems, and you know, we're involved with a state where the mom, everything, 4 kids divided equally, but for the one son, it didn't go to him directly. It went into what's called the testamentary trust within the will, and the sister held the money in an account because he was an alcoholic. He had alcohol problems, you know, working in and out. You go, listen, if you give an alcoholic $100, they go to the liquor store and buy $100 worth of booze. If you give $1,000, they go to the liquor store and whatever they can fit in their car, they would take off with. So instead, mom set it up where the money, and so now this son's ex-wife files a complaint to Superior Court saying, "Oh, I'm owed some alimony and some other money. I want you, judge, I want you to compel that the executor to pay the money that I'm owed over to me." I say, Judge, the whole reason for setting up this kind of testamentary trust thing is to give the sole discretion to the trustee what should be paid. If the trustee says, you know, I'm not paying X, that's their right. It actually protects it from, the only thing that protects it from taxes, from Medicaid, nursing home, etc. Sole discretion of that trustee. Judge goes, looks at my brief, goes, Mr. Vercammen's right. Let's say, you know, that's the way. We also try to put in a clause that says no one under the age of 21 gets money outright. It should be used for health education, college, etc. Because, hey, you know, if I would have got a chunk of money when I was 19, would I have invested it wisely, or would have I said to my buddies? He goes, "Hey, we're in the house in Seaside this summer. I'm not working. One summer I worked 2 jobs because you know, I worked a full-time job in a factory, the midnight shift. Then I would go and you know throw together some piece of bologna on a white bread and go over and work my job at the county parks department. So you know, you have a clause that you know the kids don't get money can be used. If there's minor children, there's always a clause. You know, guardian 1 and guardian 2. For everyone here that has, you know, children that have minor children, they should have a will. We do some wills sometimes for people, they don't got 2 cents. They live in an apartment, you know, or they just bought a house, but, you know, they got to use, but they got children, you know, it's that person's grandchildren, and they cover the will saying, listen, if something happens to the 2 of you, who's going to get custody of the you know, the grandchildren, because otherwise a bald white guy decides. You know. All right. Now, a couple people write stuff down. Write down self-proving will. Under the old law, that meant that there's 2 witnesses that signed, but then they would have to go to the surrogate's office and sign this affidavit saying, I was the witness. And when my grandma passed, we finally find one of the witnesses that worked in the law office, and she goes, yeah, I can sign that form. My fee's $500. My dad goes, I'm not paying you $500. He goes, okay, get the other witness. Well, she's dead. Yeah, my fee's $500. Now, we could have said, screw you, but it would have cost us $5,000 to go in front of the judge. So, this change in the law created what's called a self-proving will. Self-proving will. And that, you know, so with the language is the person signs twice, the 2 witnesses sign twice, the attorney and notary signs twice. That way the witnesses don't have to be located. And one of the things the county surrogates also says, when these people do these cheap things themselves online, they screw it up because, you know, notwithstanding that some companies said valid in every 50 states, it's not self-proving, and then they gotta pay more money to go find witnesses, etc. So, like the surrogate says, don't cheap at it. Also, the will should have a clause that says no bond required. I mentioned that when there's, if there's no will, the administrator gotta take that bond. If the will does not say no bond required, the executor takes it.
Thought somebody was passing out the heat.
What is it, doggy? You know, it's funny. I'm very smart when I go to sleep now, and I turn it off the ringer because when we were away, sometimes people would be Googling something, go to our website. Well, I want to ask the attorney a question. It's 2 a.m., pal. Okay. Yeah. Okay. Let me have your credit card number, and I'll start answering your questions. And second, if you know, sometimes like kids or grandkids might be receiving Social Security, disability, not regular Social Security. So if they get money, then they lose their eligibility. So sometimes people say, "Listen, I love this grandkid, this kid, but they would lose their entitlements. So I'm not going to put it." Some people spend big bucks on setting up what's called a special needs trust, but most people say, now, if you don't have a will, get it done. Okay? Don't be a putter-offer like Carl. Now, Carl was this retired engineer. And you know what engineers are, they want to read through everything. Not a trained engineer, but you know, the ones that, you know, got a degree in it. They want to read everything. He goes, oh, I want to read more up on this. Carl, you don't need to read anything. Listen, I went to law school, I passed the bar. You know, I go to seminars all the time. I lecture for the bar. I wrote a book on this stuff. You don't need to read anything. I want to read Carl. When I had knee surgery, I only asked the doctor, had he done it before? I didn't read anything all about it. How he was going to do it, I didn't want to know. You know, I got enough. I goes, 2 years later, who calls him? Carl's daughter. Oh, do we have Carl's will? We found your pamphlets in his stuff. No, we want to read more. It cost him a lot of money. Okay. So, get your stuff there. By the way, anyone who goes to our seminars, we typically, attorneys all charge a consult fee, but if someone attends one of our seminars and fills out our short questionnaire within 30 days, we do a free consult. Now, let's go to a different topic, okay? Revocable trust, living trust. My mother-in-law is still around. She's 93 years old. We went to visit her on Saturday. She used to call me every other year. I want to come in and get a trust. I want to get a trust. I would say, we watching Susie Orman on TV. She says, oh yes. So Susie Orman is exactly right. If you live in New York, California, Florida, where probate takes 3 years and costs $15,000. The New Jersey probate circuit's fee is about $190. The circuit just needs the original will, original death certificate, check for about $190, and you get your papers. Let's see. So I asked everyone, why do you think you need to spend between $3,000 and $6,000 transferring your assets into this elaborate trust? And it can't be because your friend read somewhere, or your friend who lives in another state. Now, if you own property, real estate in Florida or California, then it's for you because it should be owned to avoid that. But probate irrevocable trust. Probate in New Jersey is easy and inexpensive. Most people don't need to spend $5,000–6,000 setting up a trust. If someone says, I don't care, I want to do it, great, but I want to be honest with people. I don't try to sell it because it's not really something, it's kind of like and you bought a new car, oh, would you like the special undercarriage protection? No, I don't need that. You buy something, oh, would you like to buy the 3-year warranty for another $200? He goes, the thing I bought was only $100. Why do I want to buy this thing? It should work. Okay, a revocable trust does not protect assets from nursing home. It doesn't protect anything from taxes or reduce taxes.
That's what they say it does.
Yeah.
It
They
protects
lie.
you from going to the.
That's different. That's a different kind of trust. And also, sometimes the trust salesman, because they're trust salesmen, they say, oh, like, a will is probate. It's public record, and people know about it. Who cares if people know that monies are going to? It doesn't list your assets. Unless someone's leaving their their money to ISIS. Who cares what people know? Okay, so having said that, listen. If everyone wants to spend $5,000 on having fancy revocable trust done, I'm good. But again, I remember talking to my best man. I goes, hey, I'd feel bad about trying to sell your mom on something that she don't need or my neighbors. Now, a different kind of trust is a irrevocable trust to protect assets if someone has to go into a nursing home, etc. The requirements are you don't own the assets anymore. They're owned by a trust. There's a new tax ID. The attorneys that do it charge between 12 and 15 grand, which is like a month in a nursing home. And it's a 5-year look back. So if you spend this 12, 15 grand, and in 4 years, 11 months later, you got to go into a nursing home, well, it doesn't protect the assets. People one time, this daughter brings in mom. And the daughter goes, Mom wants to protect her assets. Well, this isn't my first day. I can smell daughter wants to protect her inheritance. I don't care about mom. When do I get my money? Mom, when are you going to die so I get my money? Mom wants to protect her assets. See? First they say to the daughter goes, why do you take out long-term care insurance for your mom if you're concerned? Well, I won't spend any of my money. Yeah, I think so. Let's see. And then it goes, then she goes, the daughter says, what did I do? Me personally? I'm not transferring my assets to become penniless. Medicaid is welfare. The way that it works is if you have money, the house if someone's married, is protected. But if you have money under the law, you pay your own way. But why would I want to be in the dirtiest, smelliest welfare Medicaid nursing home when I worked my whole life hard to be comfortable so I don't have to go into the dirty, smelly nursing home? Let's say there's nice ones in this. Let's see. I was a newspaper boy, delivering newspapers in the rain on my bicycle and collecting nickels and quarters from people. And it wasn't so my son, Dr. Brendan, the dentist, could have a bigger boat. It's so that I get the best care in the last weeks and months of my life. Right? So if there's nothing left over, there's nothing left over. Some of my long-term clients, they had a will, and they worked hard. They had a house. He was in insurance, a decent amount of money, and I'd say. She goes into the nursing home 5-6 years ago because she put the house at bi-level and she can't walk. Then he goes to the nursing home. Then he passes, and then by the time she passed on Sunday, the son goes, there's nothing left. I goes, well, let's see, bad for us, good for her. Because she was in the Reformed Church on Route 18. It's kind of clean, it's nicer.
Beautiful.
Who remembers before cell phones? How were we able to do stuff? So, before cell phones, my grandmother lived till almost 105. She's in a nursing home on Route 9 in Lakewood. So, I say to my wife, hey, listen, I'm doing this 9-mile race in Freehold. My buddies are driving me down. Then they're gonna drop me off to see my grandmother. Why don't you drive down and, you know, bring the kids, they can see their grandma, their great grandma for the last time while she can, you know, talk and have a conversation. It's 100 years old. Okay, so my wife's driving down Route 9, she's saying, nursing home pulls in and says, okay, I'm here to see Virginia Vercammen. You know, person at the dead, and also my wife was saying, ew, this place is horrible. It smells of pee and dirty and old and ew. And then she goes, oh, I remember my wife was 2 years ago, we were at her apartment, she made us spaghetti for dinner. And he goes, person at the desk, Jerry looks, no, not here. What do you mean you're not here? What do you? They go, they lost Ken's grandmother. And he goes, wandering outside on Route 9. He goes, no, I'm here to meet my husband, Virginia Vercammen. He looked up, Fountain View Nursing Home. He goes, this isn't Fountain View, this is Smelly View. Fountain View is down the road, nice, there's a fountain in the front, it's white, it's clean, so, I'm saying, why be a martyr so that your kids can have a bigger boat? Okay. Make sure your will is at a place where your executor number 1 can get to an executor number 2. If you live by yourself, a lot of times people say, listen, I might as well have everything with executor number 1 because they need it more than me. If I'm gone, I'm gone. Same thing with the power of attorney. Okay, I'm only supposed to go 35 minutes, but let me quickly go through power of attorney and living. Will takes care of your assets if you pass away. What a power of attorney does is while you're alive, you're giving the ability to someone you trust to be able to make sure your bills are paid and act on your behalf legally. You're not giving away your rights, you're not declaring yourself crazy, just, so it's good to have, because you're giving the power to someone, and that way, hey, no one can, know, oh, I'm gonna get hit by some dumbass kid, while I'm driving, who's on their phone, sending a text message, and all of a sudden, you're in a hospital and your arm or leg are broken, you need someone to do your stuff, or if you have other medical stuff. So you want to get that done. Once a week we get a call. I need to get power of attorney over mom, dad, my brother. Well, someone can't get power of attorney over anyone else. That person has to affirmatively sign a paper and give it to you. Now, my office has to ask, because it goes, okay, can dad talk to us over the phone and can he sign a piece of paper, yes or no? And we can email that for him. If the answer is no, then we can't do it. Well, what can we do? We need to sell us. He goes, you gotta go through this expensive guardianship proceedings. It's gonna cost you about $4 grand. You could have spent the $200, had a power of attorney, but didn't do it. Too late. If someone says do it, I goes, do it now. Well, we'll wait till the spring. What are you waiting for? I also recommend that a will is good forever. A will is good if you move to another state. There's no statute in New Jersey that says how long a power of attorney is good for. So we're now saying we recommend a new one be signed every 5 years. It could be the same stuff. But that way, if you present a power of attorney to a bank that's 10 years old, they're going to give you a hard time. Now, the other thing the surrogate said was, avoid cheap things online for the power of attorney. There was a change in New Jersey statutes, actually an improvement, because some of the banks and institutions were giving people a hard time, wouldn't honor it. Oh, it wasn't done in our form, or we never seen it. So the statute says, if it makes reference to New Jersey statute, the bank or institution doing business in New Jersey has to honor it. But it has to make reference to section 2 of PL 1991 C95 C 46:2-11. And the cheap forms online don't have that. So, someone using a cheap form online don't have that, they're gonna spend the $4,000, on guardianship, but maybe they can sue that company, that did the online, they get their $15 back. Okay. A power of attorney is either effective right away or only upon disability. If it's effective right away, it's called durable power of attorney, stays in effect if someone comes to visit. Springing power of attorney is only if someone's disabled, only springs into effect then. My client, Joe the carpenter, he's looking at this like, Katie, I don't understand this legal stuff. He goes, I'm a carpenter, I work with hammers. Explain to me in carpenter language. I goes, okay, listen. If it's effective right away, you put your son as your agent, the guy. That means he can steal all your money right away and go to Cuba where it's warm. If it's effective only upon disability, he has to get a note from a doctor before he steals all your money and goes to Cuba. Knowing that you trust your son. He goes, all right, I trust my son with my life. Good, make it effective right. Make it effective right away. Don't delay. Okay? All right. Power of attorney. Lastly, living will advance directory. Okay? That's the document where you're giving a written instruction to households and doctors saying this. If I'm at the end and I can no longer talk, I can't think, I can't feed myself, etc. You're giving instructions to hospitals and doctors saying, listen, this is what I want. And most people say, listen, if I can't open up my eyes on my own, I don't want to be on respirators, I don't want to be on feeding tubes, I don't want anything done. I had a good life, and if every day I'm suffering or, do I want to be around? Let's say, now also in the, we took some language from the State Medical Society, that way doctors are familiar with it, and we also added what's called the HIPAA clause, because under the HIPAA law, there has to be something in writing that authorizes a child or someone to even talk to the doctor. So we added that, and it's a good idea because you don't want to not have it, and then all of a sudden someone is at the end, a stroke, whatever, and the doctor says, okay, there's no hope, should we remove life support today? I remember a doctor asked me that for someone who wasn't even a family member. I was a power of attorney, but the person didn't have a living will. Geez, I feel bad about it. You know the right decisions for someone who's 92 years old that's not going to open up their eyes again, lying in the hospital bed, but I couldn't even do it for my first daughter. So today's a good day for it. So the whole idea is that, and just kind of like, and lastly on the living will. In a lot of families, there's the one kid that was always involved with helping out mom or dad or whoever. Okay, and sometimes there was the one that wasn't that helpful. And or wasn't really part of the family. And sometimes though, when the person's at the end of the hospital, that person that wasn't involved, walks into the room and goes, okay, listen, I'm in charge now, and this is what we're gonna do. And the answer is, no, you ain't in charge, because under the living will, this is the person in charge. And you're lucky we even let you into the room because you weren't around to help when we needed you to help. End of story. So, with that, I will tell about briefly afterwards to answer a couple questions and help yourself to those brochures there. And anyway, my name is Ken Vercammen. And for those people who are watching or listening on the internet machine, our office number is 732-572-0500 between 10 a.m. and 2:45. That, if the call comes in at 8 AM, then it gets transferred to my phone, and I'm driving in, and it goes. I don't- But the phone number's on, okay, so my colleague Dan Fabrizio is a financial advisor, and he's gonna talk a little bit about that, and he's gonna know about afterwards for a little while and answer some questions.
When you mentioned the bond, right? You have to-
Yeah, I'll talk to you afterwards.
Okay. I just want to know where.
Good morning. Again, my name is Dan Fabrizio. I'm a financial advisor with New York Life.